All right, in this video, I'm going to explain what to include in your preservation of evidence and litigation hold letters, and more importantly, how these letters can help your insurance adjuster successfully defend claims against your company. I'm Santiago Cueto, board certified international business law expert and best-selling author. In 30 years of practice, I've defended thousands of claims spanning the entire litigation landscape, from corporate wrongdoing and fiduciary breaches to the full range of tort and casualty disputes. Now, your company just got hit with a lawsuit. Your insurance adjuster calls, they need documentation, they need emails, they need security footage, and you realize half of it might already be gone, deleted, overwritten, lost forever. But here's what most business owners don't understand. The duty to preserve evidence begins the moment you reasonably anticipate litigation. Not when the lawsuit is filed, not when the lawyer sends a demand letter, the moment you know a claim is coming. So what does this mean practically speaking? Well, it means you need a system. You need a preservation letter that goes out immediately, and that letter needs to be comprehensive. Let's talk about who needs to receive this letter. Start with your own employees. Anyone who might have relevant information needs to get preservation notices. This includes managers, supervisors, and frontline employees who witnessed the incident. It includes your HR department if it's an employment claim, your safety team if it's a premises liability claim. Your IT department always gets included because they control your electronic data. But don't stop within employees. Your vendors might have relevant records. Your contractors might have documentation. And your security company might have video footage. Anyone who could possibly possess evidence related to the claim needs a preservation letter. Now, here's where most companies make their first mistake. They send out a vague email saying, preserve everything. Well, that doesn't work. Your preservation letter needs to be specific. Start with basic case information. Include the date of the incident, the names of people involved, the location where it happened, and the type of claim being made. This gives everyone some context. They understand what they're looking for. Then list specific categories of documents. Don't just say all documents. Say all emails sent or received regarding the incident. Say all text messages discussing the claim. Say all photographs taken at the scene. Say all maintenance records for the equipment involved. Say all training materials provided to the employee. I think you get the idea. Be explicit about electronic data. This is where evidence disappears most often. Tell people to preserve emails in their sent folders and deleted folders. Tell them to preserve text messages on company phones and personal phones if they use them for work. Tell them to preserve voicemails, instant messages, and social media. Video footage deserves special attention. Security cameras typically overwrite footage after 30 days or 60 days. Your preservation letter must identify exactly which cameras and exactly which time periods need to be saved. Be specific about dates and times. Don't say, preserve the footage. Do say, preserve all footage from camera 3 in the parking lot from October 15th through October 17th between 6 a.m. and 10 p.m. If you're enjoying this information and finding it helpful, do me a favor and hit that like button below and subscribe to my channel. I share practical guidance for business owners every single week. These are the strategies that protect your company. Now let's talk about physical evidence. If there's a defective product, it needs to be preserved. If there's damaged equipment, it stays exactly as it is. If there's a torn floor mat that someone tripped on, nobody touches it. Your preservation letter should also identify specific physical items by description and location. Now here's something most people overlook. You need to preserve metadata. So what is metadata? Metadata is the electronic information about your documents. When an email was sent, when a document was created, when a file was last modified. This information can be critical in litigation. Your IT department needs explicit instructions to preserve metadata when copying or backing up files. Your preservation letter should also explain the consequences of spoliation. That's the legal term for destroying evidence. Employees need to understand this isn't just about following company policy. Courts can sanction individuals personally for destroying evidence, even if it was by accident. This creates accountability. Include specific instructions about document retention systems. Tell people not to delete files following normal retention schedules. Tell them to suspend auto-delete functions on email systems. Tell them to stop shredding documents that would normally be destroyed. Your regular document retention policy gets put on hold for anything related to that claim. Now, here's how this helps your insurance adjuster defend your company. When your adjuster receives complete, well-preserved evidence, they can evaluate the claim accurately. They can identify weaknesses in the plaintiff's case. They can find documentation that supports your defenses. Insurance adjusters deal with spoliation issues constantly. When evidence is missing, they have to assume the worst. They can't rely on witness testimony alone. They need documentation. They need objective proof. A comprehensive preservation letter also shows good faith. It demonstrates that your company took its legal obligations seriously. If the case goes to trial, your lawyer can show the judge your preservation efforts. This matters if the other side claims you destroyed evidence. Good preservation letters also speed up the claims process. Your adjuster doesn't waste time tracking down missing documents. They don't wonder whether evidence exists somewhere else. Everything is identified, preserved, and accessible. This allows faster evaluation and potentially a much faster resolution of your claim. Now, here's a practical tip. Create a preservation letter template right now before you need it. Have your lawyer review it. Customize it for common claim types your business faces. Keep it ready to deploy immediately. When you send the letter, require acknowledgement. Recipients should confirm in writing that they received the letter and understand their obligation. This creates a paper trail. It also increases compliance. No one will ever have to second guess whether your employees received the letter. You'll also want to follow up regularly. Send reminder emails, check with department heads, verify that IT has suspended normal deletion protocols. Preservation isn't a one-time notice. It requires ongoing monitoring. And again, document everything you do. Keep copies of all preservation letters. Keep records of who received them. Keep acknowledgement forms. Keep evidence of follow-up efforts. If spoliation allegations arise later, this documentation will absolutely protect you. Oh, and one more thing. Don't wait until litigation is certain. If you think a claim might be coming, send the preservation letter. It's better to preserve too much than to lose critical evidence down the road. You can always stop preserving later if the claim never materializes, but you can't recover evidence that's already been destroyed. Your preservation letter is your first line of defense in litigation. It protects evidence, it protects your company, and it gives your insurance adjuster the tools they need to defend your case effectively. Take this seriously. Create your template, train your team, deploy it quickly when needed. The few hours you spend on preservation letters can save you months of headaches and potentially millions in damages or even sanctions. Now, if this video helped you understand how to protect your company, show your appreciation, hit that like button and subscribe to my channel for more practical legal guidance. And share this with other business owners who need to hear it. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my next videos right here.